Good morning, good afternoon, colleagues, and welcome to today's Modern Criminal Law Review Symposium on Chloë Kennedy's important new book, Inducing Intimacy, Deception, Consent, and the Law. My name is Sarai Chisala-Tempelhoff, and I'm delighted to serve as your moderator today. I work with the Gender and Justice Unit in Malawi, focusing on gender equality and legal reform. Today's symposium brings together an exceptional group of international scholars to engage with Professor Kennedy's important new book. Her work not only tackles a timely topic that resonates across jurisdictions worldwide, but also takes an excitingly interdisciplinary approach to its subject matter. As a result, it provides a wonderful platform to explore a wide range of issues, from sex offenses, consent, and deception to questions of identity and criminalization, and from multiple perspectives, including doctrinal, historical, comparative, and theoretical approaches. Our symposium today embodies the spirit, featuring contributions from scholars representing 9 countries and across 4 continents, facilitating the kind of broad and diverse exchange across countries, systems, and disciplines that defines the Modern Criminal Law Review project. Given our tight schedule and the number of contributors, I'll be keeping us moving promptly through our agenda. So let me now turn to Professor Kennedy to introduce her work. Chloë Kennedy is at the University of Edinburgh, where she works on criminal law, legal theory, and legal history, and she's the author of Inducing Intimacy, Deception, Consent, and the Law. Chloë, the floor is yours.
Well, thanks, Sarai, and thank you so much to everyone who's here, not least, and certainly, in fact, probably most, those who are generously giving their time and energy to comment on my book. So I'll just say something brief about what the book is about and why I wrote it, and hopefully there won't be too much overlap with what others have to say. Essentially, this is a book about how law has been used to provide what I call redress. So by that, I mean compensation or punishment for what I call in the book deceptively induced intimacy, which is essentially sexual activity or sexual and/or romantic relationships that take place in the wake of deception of some kind. And I look at how law has been used in this way across what I call the modern period. So that's basically around the mid-18th century to the current day. And I had 2 motivations for writing this book. The first was really, I guess, expository, trying to see exactly how law has been used for these purposes, and to explore how we've got to the point where some, but not all, instances of deceptively induced intimacy appear to potentially warrant criminal punishment. And then related to this aim is, I suppose, a more critical or evaluative ambition to ask whether these developments are, inverted commas, a good thing, and if there may be a different way of going forward and asking questions about how the law could be used to respond to these kinds of behaviours. Now, the book actually looks at a range of different areas of law, some aspects of marriage law, so ways that marriage was formed, some rules around what's called nullity of marriage, so where what looks like a marriage isn't actually a marriage in law. It looks at a few different civil wrongs, so torts in some jurisdictions, delicts in others, and some crimes too. And the range of those we can perhaps get into in the Q&A if anybody would like to do that. But because we don't have much time, I'll just outline 3 of the main findings of the book and then 3 of the more critical evaluative arguments that I offer in the book. So in terms of findings, one of the first findings is that there has been across this period a decline in laws that deal with deceptively induced intimate relationships, and a rise in, a growth in laws that concern deceptively induced sex. The second kind of major finding of the book is that there is, across this period, an increased punitiveness. So there is, for example, there are examples of conduct that used to be dealt with primarily or exclusively by the civil law that's now subject to criminal punishment. And there's also been an increase in the potential, the seriousness with which the punishments, try one more time, the seriousness of the punishments that might apply. So it's not just that more criminal law is used, it's more serious criminal laws are used nowadays. The third finding is that the, if you like, cultural scaffolding that used to keep these laws relatively clear and predictable, which was predicated on marriage and its significance culturally and socially, no longer performs that task. So those are kind of the three main findings, I would say, of the book. And then in terms of arguments, I suggest that in light of these findings, we may wish to think about and think critically about whether there's space to consider different and perhaps additional laws to deal with these deceptively induced relationships that, as I mentioned, have fewer legal forms of redress nowadays. There's a host of, I suppose, what could be called kind of legal doctrinal questions around laws that are used in this realm. So this might be, for example, the question of whether we ought to structure these laws around consent. If we do, how does that work? Should not disclosing information be treated the same as, i.e. potentially subject to redress in the same way as so-called active deception is? What kinds of temporality should the law use? How far back in time should it be concerned with looking, and with what kinds of potential consequences should it be concerned? And I offer some suggestions in the book about how those doctrinal questions might be answered. That's rests on the historical analysis. And again, maybe I can say more about that if the opportunity arises during people's, either after the presentations or in the Q&A. And then the final argument of the book is that we might benefit from a new way of trying to anchor laws that are used to deal with these kinds of behaviors. Another way, a new way of making them reasonably predictable and clear in their operation. And I suggest that a new culturally informed account of why sex matters or tends to matter, and same goes for intimate relationships in the modern age, that turns on contemporary theories of self-construction. So just in very, very, very brief terms, this argument goes something like this. We all are responsible to some extent in constructing our sense of selves in the modern era, and that's highly idiosyncratic. It's a very individual process, but we do it using kind of building blocks that are culturally specific. So there is the potential to use the information we have about the sorts of roles and I suppose experiences people have that tend to go towards building up this sense of self, and from that extrapolate a list of, or a set of deceptions, subject matter deceptions that might typically matter to somebody when it comes to their decision making around sex and intimate relationships. So I think that's probably my time up. So I'll just finish there and really look forward to hearing what everybody has to say, particularly given the breadth of backgrounds and jurisdictional focuses. So yeah, thank you so much for the chance to hear your views.
Thank you so much, Chloe. I know that it's going to spark some incredible conversations. And we are lucky that our first panel is bringing together perspectives from Brazil, Sweden, and the United States. We'll hear from Tatiana Badaró, Bladini, and Beatriz Camargo, as well as Aya Gruber. So Tatiana holds a doctorate in law from the Federal University of Minas Gerais, where she completed her thesis on the criminalization of abortion. She has been a visiting researcher at the University of Toronto and currently works in criminal law in Brazil. Tatiana, please proceed with your presentation.
Thank you so much, Sarai. And hello, everyone. It is truly an honor and a pleasure to take part in the symposium alongside so many highly qualified colleagues from around the world. I want to thank Professor Marcus Gruber for this amazing opportunity. I also want to greet and congratulate Professor Kennedy for her insightful and inspiring work. Reading it and engaging with these arguments has been a very enriching experience. Like Professor Kennedy, I believe that the scope of deceptions that should attract attention from criminal law must be limited. However, while her work suggests that authenticity is a better guiding principle than autonomy for deciding which types of fraud should trigger legal intervention, my paper defends the view that sexual autonomy should remain the core value behind rape laws, including laws on rape by deception. But despite this difference in theoretical foundations, I found that I share many of Professor Kennedy's views on which kinds of deceptions should matter to criminal law. Much of the information she identifies as important to self-construction is also crucial to sexual autonomy. However, my paper focused on two groups of cases where an authenticity-based and an autonomy-based framework might lead to different conclusions. One, cases involving gender deception, and two, cases involving explicit conditional consent. So my paper compares Professor Kennedy's views on these two topics from the standpoint of authenticity with my own views based on autonomy. I began by explaining how I understand the right to sexual autonomy. Like many scholars, I see sexual autonomy as having both a negative and a positive dimension. The negative dimension is the right not to be subjected to any sexual act against one's will or without one's consent. And the positive dimension is the right to express and experience one's sexuality in line with personal desires and preferences. Sexual fraud, in many but not all cases, violates only the positive dimension. And I argue that the law should not protect the positive dimension to the same extent as the negative one. This is because legally recognizing positive rights often means placing positive duties on others, which may conflict with their own rights, such as the right to privacy. Let me give an example, so-called gender deception cases. Professor Kennedy argues that a person's biological sex is information relevant to their partner's self-construction. So if a transgender person does not disclose their gender history, this may be seen as interfering with their partner's process of authentic self-construction, and therefore as wrongful deception. From an autonomy-based view, I see it differently. In these cases, only the positive dimension of sexual autonomy is affected. The negative dimension does not include a right to know someone else's gender history before consenting to sex. People may have a preference to only have sex with cisgender individuals, and they are entitled to that preference. But they do not have a legal claim to that information because others also have a right to informational privacy. So in my view, when a transgender person withholds or even lies about their biological sex, they are exercising their right to privacy and are not committing a legal wrong. My paper also engages with cases where one sexual partner gives explicit conditional consent. For example, saying, I will only have sex with someone who meets condition X. Professor Kennedy includes in her list of legally relevant deceptions those cases where someone lies about the fact that the other party made an explicit condition of consent. I believe this approach risks allowing criminal law to intervene in situations where the deception, while morally wrong, does not justify the use of state power. Take a simple example. Someone lies about being a natural blonde after their partner says they only sleep with natural blondes. There can be a strong moral duty not to lie or mislead others, but not every moral duty should become a legal one. Only in specific situations should a moral duty to tell the truth create a legal obligation. In the sexual context, such a duty exists when the deception affects the negative dimension of sexual autonomy. So, for example, when a person is misled to think they are being subject to a medical exam, when in fact they are engaging in a sexual act. But if the deception relates only to the positive dimension, someone's personal sexual preferences, I believe something more is needed to justify criminal punishment. Of course, my paper will try to clarify what that something more consists of, and this is an interesting matter that we could discuss later. Nevertheless, I feel that the simple fact that a person communicated a condition does not turn that moral expectation into a legal right, because the law does not and should not require individuals to cooperate with others in achieving their personal sexual fulfillment. So in very few words, these are the ideas I intend to explore in my paper, inspired by Professor Kennedy's beautiful work. Thank you all very much for your attention. Thank you.
Thank you so much, Tatiana. I can tell that we're going to have a very, very rich discussion, and I'm looking forward to hearing the rest of the contributions and responses to Professor Kennedy's work. So we are going to hear next from Moa Bladini. Moa is at the University of Gothenburg in Sweden, where she works on criminal law and criminal procedure, with a particular focus on power, justice, and gender equality. She's currently leading research on judicial autonomy and consent-based rape legislation. Moa, over to you.
Thank you very much. And thank you very much for the invitation. I'm honored to take part in this conversation. Thank you particularly to Marcus, if I may, for the invitation and arranging this meeting. So I will, as I'm in criminal law and criminal procedure law, I will take that as my starting point. And I think my paper have two main parts. So one is more theoretical, where I have decided, because I also have this critique against the traditional idea of autonomy, but I still stick to the concept of autonomy and the ideal of autonomy, and revisit and try to rethink it instead of abandoning it. And secondly, I will have a short empirical visit into the courtroom where the rape trial in Sweden is applied, and where assumptions about intimacy in rape trials is actually rather, or could be seen as rather, applied in relation to how to understand the ways or the rationales of the victim survivor rather than the offender. So that is the two parts that I'm going to try to talk a little bit about. And first, I will just begin with very, very briefly say something about the rape regulation in Swedish criminal law. We have I still call it a new law, but in 2018 we introduced a major legal reform where we transitioned from a coercion-based model to a consent-based one. So under the current law, the sexual acts are criminalized when they are not performed voluntarily. So we use the term voluntariness instead of consent. And the thing is that the court is supposed to, when assessing whether participation is voluntary or not, particular considerations is given to whether voluntariness was expressed by word or deed or in some other way. And the preparatory works states that this assessment shall be based on the situation as a whole. So this includes the context of the interaction, the complainant's behavior, and the accused awareness or the lack thereof, before and during and after the event. And this model is sometimes described as a communicative model. And also very particular, I think, of the Scandinavian or Nordic countries is that the victim survivor is a party or have a right to become a party to the prosecution and the trial. And in addition, the complainant has a right to legal support. So there is a victim's counsel supporting the victim in terms of legal advice, assistance with the evidence, advocating for compensation, and also emotional support, which is an important. So I will discuss the idea of autonomy, so that's the legal construction, but also then how it's applied in practice. So while the reform marks a formal transition from coercion to voluntariness, the way Swedish courts interpret sexual encounters still relies on deeply embedded ideas about behavior, credibility, and normative sexual conduct. And the legal judgments are often reflecting assumptions about what constitutes rational action, legitimate intimacy, or believable resistance. So, as Kennedy notes in her book, contemporary legal regulation of intimacy shifted to an individualized focus on autonomy, and this is also, of course, the situation in Sweden. And this problem is especially visible in the context of rape law, where the idea of voluntariness appears deceptively simple and yet remains conceptually fragile. So I will argue that the core difficulty lies not just in applying autonomy, but in how autonomy itself is understood and lived. So I have, together with a colleague, Dr. Vanna Svedberg Andersson, developed a concept of lived autonomy, where we say that autonomy is not a state that you enter and in which you have no relations and you're detached from the world, but it has to be understood as relational and placed in time and space. So that's the main issue, or the main argument. Okay, so that's... So we argue that this reflects the traditional idea reflects an idealized and unrealistic model of legal subject. So rational, self-contained and emotionally detached, which is not, incapable of expressing clear and stable intentions at all times, and unaffected by fear, dependency, or gendered power relations. And of course, the law, or the legal construction in Swedish criminal law, in certain ways recognizes that individuals are not always capable of saying yes and no, but it's a very simplified construction. So it's specific situations where you recognize that the subject can say yes, but actually, or say yes, but actually cannot say anything else. So some kind of constraint. So I think I will develop this more if there is time later on. But I will also go into the understanding of autonomy and voluntariness and how it's assessed in practice, and also the interpretation and meaning of intimacy and the behavior that surrounds it. I haven't thought about it as intimacy and understanding of intimacy before, but your book helped me to see new things in our data. So I recently we are publishing a book called Challenging Legal Core Values, which is co-authored with Professor Åsa Wettergren and Associate Professor Sarai, both sociologists, where we have been studying about 20 rape cases from District Court, Court of Appeal, and we have been interviewing all legal actors. And we have seen a lot of things in those trials, but what I wanted to discuss here was two gendered logics of interpretation that we call his sense and her sense. So his sense is the male-coded logic that often structures legal reasoning. It relies on assumptions of linearity, rationality, and sexual predictability. And it appears in trial in questions like, why did she go home with him? Why did she stay overnight? Why did she lie under the same blanket? Or why did she remove her trousers when she went to bed, for example? And these questions construct a narrative of implied consent. They suggest that she acted in a way that signaled sexual willingness and that she later objected or changed her mind. She must be inconsistent or even deceptive. So what we saw in all those trials, almost every trial and a majority of the judgments was different kind of reasoning about her being a liar or not being a liar. And her sense, by contrast, reflects the situated emotional and affective logic that often underpins the complainant's or the victim survivor's experience. She may have stayed there for safety because it's probably more dangerous to go out in the middle of the night and perhaps meet a stranger than staying with someone you're a bit familiar with, for example. So it could be it could also be out of fear. He will be mad at me if I leave the house, so I have to stay here and we have to try to fall asleep. Or confusion or even ambivalence. But for this logic to be recognized, it needs to be translated, typically by the prosecutor or the victim's legal counsel then, into a form that the court can accept as credible, which is something that we see very seldom still in those trials. So we require not only the legal interpretation, but also an empathetic translation. So someone who tries to translate the logics of the actions of the victim survivor in this specific situation. So from this perspective, I think that your concept of inducing intimacy takes on a new dimension. So while you map the legal history of men deceiving women into sex or marriage, our findings suggest that in contemporary courtrooms, women are often portrayed as the ones who deceive through their actions, ambiguity, or a perceived regret. So I think this is interesting and something that I want to write more about. So, and also another thing is that we see that instead of very often in rape trials, the court is trying to put the situation into small pieces, and they evaluate each and every one of them, and each and every one of them has to hold the whole way. But we see that this should be, the situation has to be assessed as a whole. So you're asking for this more holistic approach, and that's also something that we argue for in our book. So we agree. So I think I will end with thank you very much for the contributions in your book, and it helped me to see and look at our data in new ways, and I look forward to continue this conversation. Thank you.
Thank you, Moa. I also have so many questions and so many thoughts. It's really, really incredible to hear from all of you. And I'm glad we have a good 20 minutes so we can flesh all of this out. So please do take rigorous notes, everybody, and keep everything in mind because all of it is so good. We will move now to Beatriz Camargo, who is at the Federal University of Uberlândia in Brazil. She holds an LLM from the University of Bonn and a doctorate from the University of Sao Paulo. Her work focuses on criminal law theory and sexual offenses, including comparative work between Brazilian and German legal systems. Beatriz, over to you to share your insights. Thank you.
Thank you, Sarai, for the kind introduction. And I also would like to thank Professor Max Duber for the opportunity to be here today. And I would like to go to the point. In her book, Kennedy observed that deception has not been seen as immoral because it invalidates consent. Rather, it has been seen as invalidating or precluding consent because it is sometimes immoral. This statement responds to theorists who, advocating for absolute protection of sexual autonomy through criminal law, argue that deception should always negate consent, just as force does. Like Kennedy, I believe that instead of personal autonomy, we need an objective value to establish which deceptions merit legal attention. But to me, although Kennedy's concept of self-construction explains much of contemporary concerns about sexual deception, it does not offer the optimal foundation for defining criminally punishable conduct. So today I would like to address one of Kennedy's premises regarding the criminalization of sexual deception. In particular, I want to challenge the idea that we should abandon the traditional distinction between fraud as to the nature of the act and fraud as to the purpose of the act. In my view, these distinctions remain crucial in criminal law when we approach sex crimes from the perspective of sexual freedom. And I would like to explain why. In Germanic Roman legal tradition, interference with autonomy has long been understood merely as a criterion for defining injury to freedom. A century ago, Carl Binding observed that while a wife who was forced into sex by her husband wasn't a victim of rape, since sex within marriage didn't go against the sexual morality of the time, the wife was still a victim of unlawful restraint because her husband had violated her freedom of action. I think this historical perspective reveals a critical insight that sex crimes have traditionally protected only negative sexual freedom, the freedom not to be subjected to sexual contact. Positive sexual freedom, in the sense of the right to engage in sexual acts, is not directly covered. So, preventing someone from engaging in sexual activity is not rape, though it clearly violates autonomy. This asymmetry raises a fundamental question. Why does the law make this distinction? If sexual autonomy were truly the protected interest, then using force to prevent sexual activity should logically also constitute rape. The answer lies in understanding that sexual freedom and not autonomy itself is the fundamental value protected. The common expression that criminal law protects sexual autonomy is only a shorthand for acknowledging that autonomy is necessary for exercising the right of sexual freedom. So the relevance of sexual fraud depends on first establishing what interests rape laws protect in order to guarantee the right of sexual freedom. And what then is the essential interest protected by rape laws? I propose it is a person's prerogative to impose limits on what others can do to them sexually. This prerogative is manifested through the requirement of consent, which serves to guarantee that what some scholars call sexual security or bodily integrity. So, bodily integrity or security explains why absence of consent should be valued as more important than consent given under false beliefs. For meaningful sexual freedom, individuals must first be confident that the boundaries they establish will be respected during sexual interactions. So, the value of bodily security is violated by force and threats, but not by most forms of deception. And in fact, bodily security is affected in cases of fraud as to the nature of the act, but not in cases of fraud as to the purpose of the act. Now, the theoretical framework I'm presenting here also helps us deal with a significant challenge in current scholarship. How do we define what actually constitutes the act that requires consent? This is important because without a clear foundation, the description of the act can be manipulated to argue that either that consent existed or not. For example, Mary may have consented to have sex with John, but not to the risk of getting pregnant by that. When we approach this from the perspective of sexual freedom and security against sexual invasions, there is no problem in describing that the act relevant. What is the act relevant to consent? The key point is that the scope of consent must be understood as the sexual contact that invades the victim's body. So we can say that deception constitutes rape when the offender uses that deception to cross the physical boundaries established by the victim. I think this helps us understand why stealthing constitutes rape, while lying about fertility does not. In stealthing cases, the victim hasn't consent to direct contact or internal ejaculation. But in cases involving lies about fertility, the deceived person has actually consented to the sexual contact itself. What they are objecting to, the victims, are the potential consequences of that contact. It is then a case of deception as to the purpose of the act. Well, so I would like to stress that this distinction between the nature of the act and the purpose of the act isn't simply a question of logic. There is a fundamental value behind this distinction that, in my view, should matter for criminal law. When someone lies about fertility, in this example, the deceived person still retains the power to control which sexual acts can be performed with them. Their bodily boundaries haven't been violated. And this brings us to an important principle. Security against sexual invasion is actually a precondition for enjoying the very right to make authentic decisions about sex. And this is precisely why it should be valued as the most important aspect of sexual freedom within criminal law. So, to conclude, I would like to highlight the main points I presented. That's first, that sexual freedom, rather than pure autonomy, provides an objective criterion for evaluating different types of sexual fraud. Second, the right to sexual freedom enables meaningful differentiation between deception as to the nature of the act and deception as to the purpose of the act. Third, only deception as to the nature of the act excludes consent because only such cases violate the victim's security regarding what is done to them sexually. And fourth, to conclude, deception as to the nature of the act should be considered prima facie rape, while deception as to the purpose of the act requires additional justification for criminalization. And in this point, I have a similar view as Tatiana Badaró just brought to us today, that in some cases, there are duties to help other people realize their positive autonomy or positive sexual freedom, and in other cases, the most cases, there is no such duty. But to finish, I just would like to say that Professor Kennedy's research has many merits, but one particularly important contribution is demonstrating that even though our understanding of sex crimes has evolved considerably, the insights from the jurists who come before us continue to offer valuable guidance for future development. And in this sense, I hope the ideas I presented can help us move this discussion forward. Thank you.
Thank you so much, Beatriz. And then we have our final panelist, Aya Gruber, who is at USC Gold School of Law, a former public defender. She works on criminal law and procedure, violence against women, and critical theory. She's the author of The Feminist War on Crime and is currently writing a new book about the criminalization of sexual behavior. Aya, the floor is yours.
Thank you so much. I have a collection of thoughts, maybe more so than a paper. First of all, I just want to thank Professor Kennedy for this really, truly impressive project, an important project. And I just want to talk a little bit about what I've been working on because it's somewhat in conversation with this project. And then kind of weave in Professor Kennedy's really important insights into the meaning of the laws governing sexual deceptions. So I have been for the past few years working on a project to understand what I'm calling sex exceptionalism in criminal law. And this is totally from a U.S. perspective. And like Professor Kennedy, the book I'm currently working on traces, it's a little more broad and therefore probably less impressively precise than Professor Kennedy's book. But basically, it traces sex criminalization of all forms in the United States from colonial times, from early American times until the current moment. And really, it's asking a basic question: what is a sex crime? And what, when, and why is sex a crime? And I think Professor Kennedy is completely right that today, the farthest back we tend to go in the United States in history is to the 70s. Like that's when rape law became a thing. And the reality is there was an underlying logic to the criminalization of sex that had very little to do with autonomy for really thousands of years of history until the very late 20th century. So the notion of sex being an assault, right? It wasn't called sexual assault. It was called rape. It was called fornication. It was called crimes against nature, bestiality, buggery. All of these crimes, only in some of them did force and the will even matter, right? These crimes, as Professor Kennedy notes with very compelling examples, were mostly, not always, but mostly in service of moral codes, marital arrangements, and gender hierarchy. One that is not so present in Professor Kennedy's book, but is quite present in mine, is racial hierarchy. And in fact, it played an essential role in constructing American rape law. And I'm not going to get all into the history of early American fornication laws and how they were meant to distinguish colonial America as a particularly moral country when compared to English fornication laws and the sort of American sexual exceptionalism. But I will say this about sort of early American history going on really up until the present, that much of the substance and practice of sex crime law was meant to discipline race, preserve racial hierarchy, and discipline modes of sexuality. And so I guess what I'm reacting against in my work is this notion that sex crimes are in a category by themselves, are particularly grave, are ripe for legal interventions, and in particular are inappropriate for most legal interventions other than individual punitive criminal law interventions. And so that sort of collection of thoughts I'm calling sex exceptionalism, what Susan Appleton has described as the idea that sex and sexualities are inherently different from all other human activities. In criminal law, sex is ontologically fixed, particularly grave, ripe for punishment. And my project seeks to dislodge the knee-jerk reaction that sex makes things a million times worse and encourage people to stop and think, for example, why do I believe that molestation, which is often nonviolent and committed by children, is of a magnitude worse than violent non-sexual child abuse? My interest was also sparked by writing my 2020 book, The Feminist War on Crime, and it explored my own long-held belief that as a feminist, the penal system, and I believed this for years and years and years and years until very recently, the penal system, which is itself a site of concentrated masculinity and sexual violence, is the key to women's empowerment. And my research confirmed that many feminists carve out gender-based crimes and particularly sexual crimes out of their larger incarceration critique and want police and prosecutors to be as tough as they are on other crimes, on sex crimes in the tough on crime era, even knowing that the distribution of carceral punishment for sex crimes disproportionately falls on men of color, poor men of color. Still, a gender exceptionalist stance on incarceration didn't fully capture the dynamics of rape reform. From turn-of-the-century temperance advocates to modern dominance feminists like Catherine McKinnon, many feminist anti-rape activists have viewed sex as inherently violating, immoral, and subordinating, and sought not equality of sex punishments to other assaultive punishments, but sex-specific criminalization. And I'll return to this in a moment. And for this reason, I think that Professor Kennedy's careful genealogical study of rape deception crimes is really scholarship at its finest. In 2016, I wrote an article called Consent Confusion, and I'll spare you all the details, but the bottom line of it was that non-consent and the way it's constructed in American law to alternatively mean states of mind and performances, compulsory performances, sex under conditions of inequality, status, and power differentials, it just was extended to mean everything and nothing. And so people could make an argument that something was consent or not consent. And the concept became so capacious and so indeterminate that it really became just a mechanism to obscure hidden value judgments. And so, what I invited and what I kind of hoped to see was people laying out exactly when is sex wrongful and why do we believe that? Because it seemed to me that the consent discussion, which was very new in the history of the law, obscured that. So I love this filling in of the sexual deception discussion with less of the sort of ideal theories of consent and more of the real history of the social values that drove the law to criminalize certain deceptions and not others. And I completely appreciate what Professor Kennedy says, that, the kind of crux of what makes deceptions appear wrongful is the context in which the deception occurs and the activity in relation to which it is carried out. And this idea that we can ex ante through any sort of objective idea determine the sex that is wrongful just sort of belies the history of how the wrongfulness of sex has been determined. And so one of the puzzles is, okay, we have autonomy, and that would seem to indicate that this wide range of sex under imperfect informational conditions is a rape, but it doesn't. And I guess I come at it a little differently, but very similarly, when I look at the 1955 Model Penal Code and how this new liberal-based frame to sex laws handled a variety of doctrines. My bottom line, it was just very, very difficult to retrofit a sex crime body of law that had been based in morality and gender and racial hierarchy and marriage with this liberal assault autonomy frame. And it did it more or less. So I think this project is wonderful, and I plan to borrow from it heavily. So I'm totally on board with 100% of that. Where I think I part ways and part significantly, sorry, Professor Kennedy, is on the reconstructive project. And that is sort of trying to create normatively the right kind of sexual deception law. So I guess where I stop is I want to understand the ways in which current sex law, including deception law, reflects these older values in ways that are hidden through the language of consent and through the language of women's rights, like whether it really is still about devastation, marriage, virginity, racial hierarchy, sexual immorality. And so mine is more of a critical project that invites people to understand the current law. And, so of course I'm down with the critical project, but the reconstructive project, as I understand it, in answering that very question of sort of the context of the deception and the nature of, the thing that is being the subject of deception, Professor Kennedy is sex exceptionalist in this space. So sex is important, and sexual deceptions, as opposed to deceptions about maybe money or, other things you do with your body, like free labor. My friend lies to me, so I help him, or somebody pretends to be my friend, so I help them move all the furniture in their house. The difference with sex is it's part of this notion of how we importantly define our lives. Right? I think that there is a statement that sex is part of the crucible of inwardly generated identity. And I find this a curiously second wave cultural feminist pastoral view of sex. And I think it is true of some people that sex is part of life-defining intimacy, but I think it is not generally true. And to the extent that it is generally true of women, it could be argued to be a problematic understanding of women that's based in some history of things that aren't so great. And so I think I want to just take, I'm at time. So let me just put two provocations on the table. I want to take a minute to question the is and the ought of it. I think we can question the is from a gendered perspective. Do men, do queer people consider sex to be a part of life-defining intimacy, a life-defining moment? Do sex workers see sex in the same way? What is the implication normatively for law if we see sex as part of this crucible of inwardly generated identity? I think that, we can have different answers to that, but it does explain, for example, the difference between, say, a woman lying about taking the pill and stealthing, right? I think the difference is, one of the feminist ways of looking at that specialness of sex is that it's bodily invasion like no others. So that would define the sort of skin on skin touching versus just a more neutral risk of disease, risk of pregnancy type of thing, which I do actually think is gender neutral. That's for another day. It also can explain the difference between, the sort of gender difference between women thinking this sort of sexual bodily invasion is all important, and men actually thinking the all important thing is having had sex with a woman, because this has history in just the very notion of immoral, bad, horrible sex being defined by the concept of same-sex sexual activity. So I guess that's the is part. And my ought part is, I'm not sure I'm so convinced that lionizing the intimacy of sex in the doctrine is good for women, good for LGBT communities, sex workers, and others. So I'll end there, but thank you so much for this really important book.
Thank you, Aya. And really thank you to all of our panelists for these incredibly insightful presentations. We now have 20 minutes for discussion. I'll invite questions and comments and start with Professor Kennedy to see if she would start by responding to some of the points that were raised, followed by questions from our panelists to each other, and then to our broader audience. We will need to use the hand up function. So if you can just find that, and I can ensure that I get to each one of you in the order that you've raised your hand when you have a point. So Chloe, back to you.
Yeah, thank you so much. This is really, really valuable for me to hear everybody's reflections on the book. And so thank you so much. I think I'm also due to say something at the very end. So maybe I'll just say something short to allow time for other people to speak. But I'll maybe just say like one or two things in response to each of the presentations, if that's all right for now. So Tatiana, I hear what you're saying, and I'm really looking forward to reading in more detail the way you flesh out that difference between positive and negative sexual autonomy, and why certain things like medical deceptions would fall on one side of that line and the other. And one of the things the book tries to do is show how the idea of there being no consent is, of course, as others have been saying in the chat, very malleable. And you can kind of, through different tweaks to tests like nature of the act or something else similar, make something fit or not. So I guess with almost all comments that come in along the lines of this specific, to put it maybe a bit bluntly, but abstract philosophical conceptualization can do the work, I guess I'm always quite skeptical, for some of the reasons that I was outlining towards the end there, because as my book tries to show, these tests are fleshed out with reference to cultural norms, and I don't see there as being almost any other way of them gaining flesh, if that sounds strange to put it like that, but I hope you know what I'm driving at. So yeah, I'm really looking forward to reading that. And Moa, yes, I really found that interesting too, what you were saying. Certainly in some of the cases I found there is also a degree of, if not direct accusation, then implication that the women who were perceived as victims were lying, and especially when it comes to things like breach of promise claims where there's compensation at stake. There was this real kind of trope about the gold digging lying woman. So yeah, there's obviously really interesting parallels to explore there. Beatriz, again, I'm really just looking forward to seeing sort of more discussion of what you have to say about freedom and how that should be and is tied to a kind of bodily oriented boundaries, because one of the things that's come through, which you will have seen in the book, in some jurisdictions when it comes to the stealthing versus fertility-based lies, is this a distinction without a difference when it comes to the rights of, say, reproductive autonomy or to be free from disease? It may be true that sex without a condom involves a physical connection that's qualitatively different, but the motivation for treating that differently seems to me to kind of, at least if not fall apart, then come under intense scrutiny when it comes to acts that can lead to very, very similar consequences and would be, in many people's eyes, I think, regarded as similarly serious. So I really, I'm looking forward to reading more about that. I just want to say sorry also for not having cited your work. I'm aware of it, and it should have actually been in the book. You're absolutely right on everything you say. I think obviously you homed in on the end there on some ways we potentially part company, and certainly do based on what you've said. But I guess I just want to say a couple of things about the sex exceptionalist strand to the book, which I agree is there. To some extent anyway. I suppose I purposely didn't engage in any comparisons with other areas of law, or how I would sort of go about framing them, because, and this itself is sex exceptionalist, I kind of do think that with respect to all these different areas, not actually only sex, we ought to kind of think of them in their own terms. So I would be inclined to look at things like, I don't know, interferences with property, interferences with other sorts of interests, even just via deception, can on their own terms, because I'm quite a big fan of trying to see things look at things in the way that they seem to be particular. And, this is the crux of the problem, I guess, is the old recognizing / reifying something, at the same time as we might look around and say, as a matter of fact, for some people, this does have a certain kind of significance. When we then code that in law, we just amplify that significance in perhaps ways that aren't particularly liberating, right? Or tend towards liberation, or removing ourselves from norms that we might see as problematic in various ways. And I absolutely agree that there's this kind of romantic, I liked how you described it as pastoral view of sex that can come into some of this writing. It can be quite kind of pious in a way. I hoped by using these conventions around construction to actually thereby, maybe without full success, demystify some of the kind of discussion around sex and its significance, because what I'm suggesting is that only some of these deceptions are potentially life extensive, particularly when they have certain consequences attached to them. I do stray into the territory of perhaps seeing sex as being maybe more significant than many people would consider it in the contemporary era when I talk about the identity of one's partner. I think that's one example where there aren't necessarily kind of downstream consequences like potentially becoming a parent, or at least becoming pregnant, or contracting a disease that is life extensive, even if it's manageable. But I think that, for many people, and I base my assumptions about what many people might feel on the literature I could find around kind of psychology and other studies that kind of have engaged with this question of how we do in the contemporary era kind of define ourselves. So yeah, I don't know. I guess all I'd say is I totally recognize what you're saying. And perhaps I ought not to have strayed into the territory of trying to do the reconstructive project, but I was so kind of driven by a desire to not just make sense of how we've ended up here, but also see if I could find some way of reining in what is a potentially very, very expansive area of law, albeit in a way that does still leave it fairly expansive. I realize I've talked for a long time, sorry, I'll stop now and leave space for others.
Thanks. I was about to say something, but I think what we'll do is we'll catch time at the end. It's good that you're already, as these thoughts are there, because we're going to go into the next round of panel discussions soon after this. And I know that there'll be, again, another round of amazing and incredible interventions. But please, the floor is open. If you can raise your hand, and you can unmute once I call on you. And at least that way I will know whose question comes next. So the floor is open to the rest of the panelists, including those who haven't presented yet, to ask each other questions. Go ahead, Rachel.
Thanks so much. Gosh, there's my brain is exploding with questions and thoughts, which I think is a testament to the rich material that Chloe's given us to think about. I have let me limit myself to one provocation or concern around the discussion of the sort of condom use deceptions versus the fertility deception. So as a kind of English lawyer, I think of this as the distinction between Lawrence, the fertility deception case, which is now the leading authority in this area in England and Wales, and the Assange case in the High Court looking at dual criminality in extradition. So if I use that language, if I trip into that language by habit, at least now I've explained to the audience where it comes from. What I say sometimes to students or to colleagues when I'm talking about this area and trying to explain, or I guess trying to offer a provocation, illustrating why I think this distinction is quite problematic, is this. What English law essentially says to individuals, and particularly to cisgender men, is if you want to have unprotected sex with someone who doesn't wish to have unprotected sex with you, don't lie about whether you're going to use a condom because that's rape. Just lie about why you should, and that's fine. And I think whether we're interested in sexual freedom or sexual autonomy, this seems to me to be sort of farcical in a way. I was really interested, Beatriz, in the way that you kind of laid out the underlying theoretical accounts of autonomy and sexual freedom. But I just wonder whether, when you think about the message that the law gives to men about what they can and can't do and how they can and can't achieve what they want at the expense of a boundary someone else is trying to draw about their body, what they're prepared to consent to, and what risks they're prepared to take. It seems to me that the distinction, as Chloë suggested in her comments, really does come under an awful lot of pressure when put in those terms in particular. We can talk about whether we should treat that as a sex crime or a different kind of crime, and the role of sort of sex offences in particular within the law. But whatever our answer is to that series of questions, I wonder if you see anything problematic in that message that the law is giving to cisgender men, or at least the law in England and Wales seems to be giving to cisgender men, and if how your theory kind of captures that concern or brackets it to one side. I hope that was sufficiently clear. But thank you so much, Beatriz, because it was, and everyone else. I thought it was really interesting.
Thanks, Rachel. Christina, go ahead and unmute. I think we should take a couple of interventions.
Okay, perfect. My question is on a very different point, but it's mostly based on Aya, what you mentioned. So I also agree that sexuality is socially constructed, and that if we see the sexual as a different moral value or moral wrong, we are also probably there prescribing some sort of hierarchy. I agree totally with your question, with what you're proposing to us. I don't know if I understood correctly. However, at the same time, my question would be, is it possible then for us to agree on what makes sex wrong without falling back to an essentialist way of treating it? That would be first. Or also just from a theoretical perspective, because I believe that, but at the same time, we are socialized, right? In different cultures, in different societies that still see the sexual harm or interaction as sometimes something that is different or that construct us differently. I think that's part of the reason why we're all here and why feminism or different movements, anti-subordination movements also exist. So my question is, how do we not reify, as Chloë was saying, also through criminal law? That's probably one of the harmless way of doing it. But at the same time, how do we still pay attention to the fact that many subordinated people, not only women, of course, are also still nowadays, I would say, seeing the sexual or being socialized in a way that the sexual is something that we can feel and that this embodiness is real, right? So that would be my question. Thank you.
Chloë and Aya, if you had a response, please go ahead and unmute.
I mean, I have a complicated response, but I'll try to make it somewhat short. I think you've really identified the conundrum is that we have to address the reality of subordinated identities without, reinforcing the conditions that create that identity in the first place, which is a very difficult thing to do. But I think part of Chloe's project, I don't want to speak for you, and part of my project is to first dislodge the notion that there is an essential and undeniable sort of female even response to what I'll say is a range of sex under imperfect conditions. And, you know, it is true that sexual violations can cause more emotional effects and harms to women than even potentially severe physically life-altering assaults that men perpetrate on men, ones that leave you with permanent physical injuries. But I also think at the same time, the discourse and law can overstate even those emotional harms in a way that is emotionally harmful. In other words, there are a lot of studies out there on the anxiety of college students who believe they can be raped at any moment and engage in sex stereotypical behaviors to reduce what they believe is a risk of rape. So I agree with you that we have to deal with that, but I think there are ways to do that better.
Sorry, I don't feel I should, don't need to say anything more at this point, but thank you so much. I'll hold off.
That's fine, Chloe. We have another round of contributions. It is time for us to just move into our second panel discussion, and then we will have an opportunity to have another discussion at the end of the next panel discussion. So our second panel takes us from India to the United Kingdom to Peru. We'll hear from Preeti Dash, Rachel Tolley, and Christina Valega. Preeti is at the National Law School of India University. She holds degrees from Harvard Law School and the University of Oxford, where she won the Roger Hood Prize in Criminology. Her work focuses on criminal law and policy, particularly the impact of the criminal justice system on marginalized communities. Preeti, please begin.
Thank you so much, Sarai, for that generous introduction. And thank you to Professor Marcus Duber for inviting me. I'm really glad to be in such great company, and I've been really enjoying myself listening to these wonderful scholars talk about Professor Kennedy's book. I'm also really grateful to Professor Kennedy for writing the book, and it covers a topic that's so close to my own research interests, but in such a different socio-cultural and historical context. I think what particularly struck me as I was reading Professor Kennedy's book was the methodology that she adopts in the book, which weaves so effectively the doctrinal, the archival, and historical issues, and spans across such a vast period without losing sight of the connecting threads. Professor Kennedy, you've so brilliantly examined these sources in such great detail, but without compromising on a macro, almost bird's eye view perspective of all the issues that you discuss. And the limited 10 minutes that I have do not do justice to everything that I want to speak about regarding this book. But what I'll try to do is I'll touch upon the parts that resonated with me the most and draw some linkages about how, in a very different sociocultural context, such as that of India, which is where my research is based out of, some of these issues do play out, but they play out very differently. And before I begin, I just want to give a caveat that everything that I'm going to talk about comes from having grown up and having done research and scholarly work in a society that's very highly stratified along lines of caste, along lines of religion, and now even more so with the right-wing government having been in power in India for almost a decade, more than a decade, in fact, and how issues regarding sexuality or women's behavior is almost co-opted in a way by the right-wing government to further police marginalized communities. So in that way, there is some overlap with what Professor Aya Gruber was talking about, like how sexual violence laws are sometimes, or like most often have been used historically to discipline race. And while that may have been true in a historical context in the US or in England and in Scotland, I feel that a lot of that is true in India today and in many other parts of South Asia, which are equally conservative or equally patriarchal in terms of how they view women's sexuality and individual sexual autonomy of both men and women and queer individuals. So the first part of the book, Professor Kennedy, that the one concerning making marriage, promising marriage, and faking marriage, that gave me a lot to think about in terms of legal responses to each of these different kinds of actions. That the right kind of sex was always that which was had within marriage, or how the wrong kind of sex could be corrected by leading it up to marriage, or by leading up to compensation or applying civil laws of seduction. Why this resonated with me, or why this gave me a lot to think about, was because in India, where I research on similar topics, and I'm currently doing a courtroom ethnography of sexual violence trials in a district court in Eastern India, the differences between 16th century and 18th century Scotland and England and 21st century India have surprisingly similar overlaps. Unlike the context, the geographical context that the book covers, the laws of seduction and compensation do not exist in India today. But breach of promise to marry cases form a large part of, in fact, like as large as somewhere between 30 to 40% of the total number of rape cases that are registered and tried in criminal courts of India. And these are tried not only as rape simpliciter, but as aggravated rape cases. And Indian law distinguishes between the two in the sense that aggravated rape calls for higher punishment, and there is also a reversal of burden of proof in aggravated rape cases. So what happens in these breach of promise to marry cases, and why are they tried as rape in India? So when a couple is in a sexual and romantic relationship, and the man later refuses to marry the woman, and that could be due to many different reasons, including that of caste or religion, more often so when the woman belongs to a lower caste or an untouchable caste, the family of the man does not agree to let him marry her, because arranged marriages, unfortunately, are still pretty common in this part of the world. So in this situation, the woman, she files a complaint of rape, and usually that is filed as aggravated rape. And while this can be easily dismissed as, and it continues to be dismissed as false cases, false rape cases, which are filed by women who want to extract money from their partners, what I have come to observe is that in a system which gives very little bargaining power to women, this is only one of the very few ways by which they can get a foot in the door. But that does not necessarily mean that criminal law is giving women the kind of solutions that they hoped for. So while a complaint may be registered and a case can reach the stage of trial, there are many problems that follow. Firstly, the man is imprisoned, and it's very difficult to get bail in these aggravated rape cases, which means that the relationship deteriorates further, and the chances of the man marrying this woman decline even further as it gets more and more difficult for him to get bail as the trial progresses. Along with that, these cases unsurprisingly lead to many out-of-court compromises, even though these are non-compoundable, non-compromisable cases under Indian criminal law. But what happens is that the family of the man tries to get in touch with the woman and say that, we will let him marry you, just turn hostile in court and say that you do not support the case of the prosecution. So eventually, with the hope that the man is going to listen to his family, or the family is going to turn around, the woman does turn hostile in court and refuses to support the case of the prosecution. All the stakeholders involved in the court, including prosecutors, defense lawyers, and even judges, are aware of what is happening outside the courtroom. And they support the victim and the accused, and they try to participate somehow informally in striking this compromise. As the woman turns hostile and the accused is later acquitted, in most of the cases that I have observed, the man refuses to marry her thereafter. So while there is a lot of money, time, and resources that are spent in pursuing that criminal case, ultimately very little emerges from it in terms of legal or even social redress for the woman. But that's primarily because social realities of caste and religion come in the way. And once someone is out of prison and relationships have anyway deteriorated almost to an inconsolable point, it becomes very difficult to reconcile and to get married to the same person again. So, what really is there for these women in India who use criminal law, who use this route to get some form of social or legal redress? And my answer to that would be that there is very little indeed. And this lack of choices or gains, legal gains, is even more striking in Professor Kennedy's work, because the book shows that how, when the ideal of autonomy in the context of intimate relationships takes a front seat, it is also accompanied by a rise in criminal law as the primary and sometimes the only response to the wrong of deceptively induced sexual or romantic intimacy. And why I say that there are overlaps between these two lines of thinking is because when criminal law of rape was amended in 2013 after the Delhi gang rape case, which had become quite infamous, feminists who participated in the lawmaking process insisted on expanding the category of aggravated rape, introducing aspects to it such as reversal of burden of proof, while at the same time not going completely the carceral way, being still opposed to the death penalty and so on. But there were still many streaks of carcerality that feminist organizations, mainstream feminist organizations in India, were supportive of. So there is something to think about there, that when feminist groups are centering autonomy, centering sexual autonomy of women and hoping that these harsh criminal laws somehow will lead to enhanced autonomy for women, that's the reality of it is that that is not happening. In fact, women are still losing out as much or maybe even more, because now there is a certain kind of hope that if I go to the police station, the police is compelled to register this FIR, or that I will be taken seriously. But in fact, they are not. They are not taken seriously at all. And I think this is also where this overlap is also where the issue of deceptive sex truly begins to unravel. And if autonomy and selfhood lie at the foundation on the basis of which the deceptive character of sex is determined, as opposed to social or culturally valued ideas, then how is it that such a position has led to, in fact, increasing the carceral capacity of the state to the maximum, where anything less than criminal punishment feels like the state is not taking deceptive sex seriously? Now, Professor Kennedy's book has also very effectively traced the journey of how that takes place and the problems that it leads to, not just in terms of moral rights or wrongs, no matter where we are on the spectrum of morality, but also in terms of legal issues such as the predictability of criminal law, or why it becomes a problem if there are a range of subjective wrongs or hurts that criminal law is trying to absorb within its fold. Again, coming back to my geography of research, this has taken a particularly insidious turn. And this takes me back to what I was saying initially about how the right-wing government has sort of weaponized women's rights to expand policing of minority communities, to discipline caste, and to find more ways of criminalizing and imprisoning and incarcerating Muslim men in India. So in several states in India where the right-wing government has been in power, they have passed laws which have made it very difficult for an interfaith couple to get married. And especially if that marriage involves a Muslim man and a Hindu woman. Now, the Hindu right-wing government, unsurprisingly, believes that more and more Hindu women are getting converted to Islam through marriage to Muslim men, and this is something that they are trying to stop. And there are marriage laws and criminal laws that are being amended across states, which are very similar to anti-miscegenation laws of the United States. In addition to amending these marriage laws, the criminal law, overall criminal law in India was recently altered in a wholesale manner. And one of the provisions criminalizes deceptive sexual relations where there's any deception regarding any part of one's identity. So that is section 69 of the Bharatiya Nyaya Sanhita. I'll read out a portion of it. It says, whoever by deceitful means or by making a promise to marry a woman without any intention of fulfilling the same has sexual intercourse with her, then such sexual intercourse, not amounting to the offense of rape, shall be punished with imprisonment of either description of a term which may extend to 10 years and shall also be liable to fine. And there is an explanation to this which says that deceitful means shall include the false promise of employment or promotion, inducement, or marriage after suppressing identity. Scholars, critical scholars of criminal law have pointed out how this is the provision that will now be employed to criminalize Muslim men by saying that they hid their identity, their religious identity from their partner. And that, in fact, is going to lead to an imprisonment of a term which is not going to be less than 10 years. So there's a mandatory minimum of 10 years of imprisonment. And what makes it particularly harmful is that it is not dependent on the complaint of the woman. It is it's a cognizable offense, which means that if the police gets a sense of such a crime taking place in any part of the country, then they can suo motu take action. It's non-bailable and it's cognizable, which is the most serious kind of offense under the Criminal Procedure Code of India. So again, like what I'm trying to say is that there are ways in which deceptive sex or deceptive sexual relationships or criminalization of that has now been weaponized to a large extent by a very conservative government, which is not working in the best interests of women, or at least not working in the best interests of expanding women's sexual autonomy. And this is the problem primarily with criminal law, that once we start resorting to it for more and more actions that we might feel are moral wrongs. And when we say we, I mean like progressive critical scholars or feminist scholars. Once we start giving space to criminal law, then that gives the state an opportunity to expand its own carceral prowess. And I think that is where I agree most strongly with Professor Kennedy, wherein regarding one of her findings, that it's not just criminal law that we are talking about, which has seen a rise along with the centering of individual sexual autonomy, but it's very serious criminal law. Like there are mandatory minimum terms. India also has the death penalty for non-homicidal rape of children below 16 years of age. And the scope for that is just increasing by the day. And that is giving more and more inroads to the right-wing government to say that, look, we are taking crimes against women seriously. We are trying to protect women. It's paternalistic, it's protective at best, and it's insidious and harmful and discriminatory at its worst.
Thank you so much,
yeah,
Preeti.
I just have one last thing to say, and I think that it's Professor Kennedy's work has shown very beautifully and wonderfully how law can be thought of in a different way, not by resorting to carceral measures or criminal law measures, but by thinking of more creative possibilities. And for that, I'm very grateful to her. Thank you.
Yeah, no, thank you, Preeti. And good that we're going back to a UK scholar now with Rachel Tolley. Might be able to respond to some of those things immediately. Rachel Tolley is at Trinity Hall Cambridge University. She completed her DPhil at Oxford University on deception, mistake, privacy, and consent in sexual activity. Her work focuses on the effect of deception and mistake on the validity of consent in English criminal law. So Rachel, over to you.
Thanks so much. Chloë, Professor Kennedy's book is just fantastic. I've said this to you before. As someone who isn't a legal historian, but who has spent, frankly, far too long thinking about this issue and sometimes driving myself up the wall with it, I just can't thank you enough for what you've given us to chew over. I think it's going to be extremely helpful to anyone working in the sort of theoretical and doctrinal space on these issues for a long time to come. Of course, I'm interested in where we go forward, and of course, you know, taking the lessons of the historical analysis that Chloe's laid out for us, but trying to figure out what we should do in this area of the law. And although there are sort of ways in which Chloe and I come apart on this issue, there is so much I agree with in the book and in your sort of reconstructive project. I tend to work within, I think, probably what would broadly be construed as a sort of sexual autonomy tradition from some kind of sexual autonomy based position. And I think for those of us who do, the line drawing question is the sort of the nettle we have to grasp, right? I agree with Chloe that there are some accounts, autonomy-based accounts, of deception, mistake, and consent validity, which risk imperiling a range of important values, not least of which is legal certainty and the predictability of liability, privacy interests, and I think there are also, you know, potentially public health and other important policy goals that can be threatened by this sort of capacious account of criminalization. In order to meet some of those concerns, I think substantive content-based limitations on the kinds of deceptions which vitiate consent or which invalidate consent are certainly required. So in other words, I think that the line drawing problem is a legitimate one that anyone working within an autonomy perspective on these issues will need to solve. How, of course, we go about doing that is the one thing that we all agree is hard to figure out. And that's pretty much the only thing I think everybody working in this area can agree upon. But it's common, I think, for people to share this instinct that some kinds of deceptions which vitiate consent are just more wrongful than others. And the worry that I've often had is how you take that sexual autonomy perspective and justify or explain the sort of scalarity of wrongfulness in a way which is consistent or coherent with a sort of individualized account of sexual autonomy. And what I really like about Chloe's work is she doesn't try to do that. She says, well, we should recognize those deceptions which vitiate consent as being grounded in something else entirely, which is linked in some way to one's sense of self and the way that sexual activity might be relevant to our sense of self, but which doesn't sort of fall within this, I think, logical paradox of trying to say, you know, of trying to have the sexual autonomy cake and eat it, so to speak. That said, I don't think we should be so quick to give up on an autonomy-based account. As I see it, there are a couple of reasons Chloe gives in the book for rejecting that approach, some concerns that she raises about it. And I suppose I have a couple of responses to them that I might offer here, some of which I think Chloe's heard before. I don't know if I've canvassed all of them with you yet, Chloe, so I guess I'll find out. So I think, you know, one point she raises in the book is that, you know, we shouldn't be in the business of responding to the bare violation of sexual autonomy because our aggregated interest in making a sufficiently free choice is not tied to any meaningful, substantive or collective interest, and that the criminal law ought to be concerned with protecting substantive collective interests only. And I wonder if, I mean, what I was going to say about this, I think I need to maybe not, I need to say something else instead, because I wonder if this comes directly to Aya's point, right? If you think that there is something particularly important about sexual decision-making, about decision-making in that domain, then I think we probably do have reason to think that we're not really interested in choice for choice's sake. We're interested in our ability to believe what other people are telling us and to take this source of information as a reliable and trustworthy basis for our own decisions in an important sphere. And the law recognizes a sufficiently collective interest in taking someone else's word on trust, and our ability to use that as a the idea that we ought to be able to use that as a reliable basis for our decision making in other domains. We don't have this kind of line drawing problem in the law of the property offences, right? Or at least not in England and Wales. Whatever you're deceiving someone else about in the context of a property transaction, or for some or where the purpose is to make a monetary gain or a gain in terms of property, or just to expose someone to the risk of loss in terms of money or property in English law, that is a sufficient basis for criminalization, at least according to the law as it currently stands. So certainly if you're going to, and notwithstanding, I think the very important provocations and questions that I has raised, see sex as an important domain of human activity where the value of communication and our ability to the value in the social practice of communication as being a sort of authoritative or a reliable source of information upon which we can build our decisions in these domains, as in some way valuable to the community, then I think we've got a reason to retain or to take more to continue to take seriously a sexual autonomy account. Where I share Chloe's concerns to a large degree is in the rule of law worries, right? I think in many respects on the reconstructive side of the project, the book is really helpful in identifying how this capacious approach to seeing deception and mistake as consent vitiating places individuals in a highly unpredictable context without any, particularly if you extend this to non-disclosures rather than active forms of deception. We're asking individuals to try and anticipate what might matter to the other person, and then to make decisions about the disclosure of often quite private and personal information with very limited guidance. And this is going to impact particularly those who are already marginalized in society more so than anyone else. And in fact, the state isn't actually asking individuals to predict what matters to the other person. Really, you're asking individuals to predict what a jury might regard as unreasonable not to disclose, at least within the context of English and Welsh law, which takes an inadvertent mens rea standard. The defendant can be convicted if they lack a reasonable belief in consent. So the sort of predictive demands on an individual in an approach which sees all mistakes as being consent vitiating is enormously onerous to everyone, but particularly onerous to individuals who are marginalized, by society in particular ways, or who are, have particular privacy-related concerns. Where do we go from there? Well, I think that only gives us a reason to reject an autonomy approach if we think a sexual autonomy approach to criminalization in this sphere can't handle the rule of law objections. And I'm not convinced that's true. I think there are a couple of techniques we can use to help us shore up some of our predictability concerns. One is a distinction between active forms of deception and non-disclosure. That's quite an unpopular view, I think, in the prevailing scholarship on this area. But we do it in the property offences, and I think it's possible to do it here. And I think that would certainly reduce the predictive burden on defendants. I think we also need to question the use of inadvertent mens rea requirements, not least because those inadvertent mens rea requirements, is it reasonable for the defendant to have a belief in legally valid consent in light of either this form of deception or this kind of non-disclosure, is a very obvious way in which, again, we're going to see the smuggling in of normative values, but this time on the part of the jury rather than on the part of the state in terms of those criminalization decisions. So I think the more we move to subjective forms of mens rea, you can't solve that problem entirely, but you can limit those risks a little bit. But ultimately, you are going to need content-based limitations on those deceptions which will be capable of vitiating consent and those which will not. And I think for me, one concern that I have, and again, this works within an autonomy tradition rather than outside of it, but if you're working within an autonomy tradition, I think this is where it becomes very difficult to say some kinds of deceptions which induce consent, particularly where the defendant knows it's going to induce consent and is engaging in that form of deceptive practice in order to obtain ostensible consent or an agreement to engage in sexual activity, which wouldn't have been given otherwise. I think it's very difficult to start drawing objective lines on the basis that, some of this conduct just isn't wrongful insofar as it violates sexual autonomy or isn't sufficiently wrongful insofar as it violates sexual autonomy. I think there's much greater progress can be made by thinking about the reasons we have not to criminalize certain forms of deceptive practices, notwithstanding the impact those deceptions might have on the sexual autonomy of the complainant. And I suppose, that sometimes can sound almost blasphemous, I think. And so despite the fact that my starting point is very far away from Aya's work, I wonder if there's a synergy there between the sort of pushback against sex exceptionalism and the point that I'm making here, which is essentially sexual autonomy is a very important value and one that we should be protecting, but not at the expense in every instance of every other value that we need to take seriously in the context of the criminal law. That includes privacy rights. That includes broader questions of social policy. Should we be criminalizing 15-year-old girls for saying that they're 17 and having sex with someone who wouldn't have had sex with them had they known that they weren't 17? I don't think that's a particularly helpful use of the criminal law. These are the kinds of questions that I think we should be asking when thinking about how to solve the line drawing issue. I suspect, we're on two roads that both lead to Rome. In the final analysis, I'm not sure Chloë and I would be very far apart in where we think the criminal law ought to land. But as I've said to her before, and I'll say again here, I think she's given those of us who work within the autonomy tradition an awful lot to think about, and our work is going to be all the better for it. So thank you so much, and thank you for the invitation to join this conversation today. It's excellent, and what a pleasure to be here.
Thank you so much, Rachel. And our next presenter is Cristina Balega, a graduate of the Faculty of Law of Pontificia Universidade Católica de Peru, and a former project coordinator of the National Strategy on the Prevention of Gender-Based Violence at the Peruvian Ministry of Women and Vulnerable Populations. Currently, she is a doctoral researcher at the Max Planck Institute for the Study of Crime, Security, and Law in Freiburg, Germany. Cristina, please share your perspectives.
Thank you very much. It's a pleasure to be here. As the final speaker, I was secretly hoping not everything I planned to say would have already been covered, but I will do my best to build on the excellent contributions that have come before me. So, as was already said, I also believe that Kennedy's work opens up a crucial conversation around deception and sexual consent. Very important, very contemporary as well. And I'd like to highlight 4 aspects of her approach that I find especially generative. But before I do so, I also want to acknowledge something that has come up in some previous presentations, discussions, interventions, the concern that criminal law, even when reformed, can reify normative scripts. reinforce inequalities, or subordinate the very individuals it claims to protect. I think also Chloé's work shows that, right? When she uses the genealogical approach. That's a concern I also share. So while I'm going to try to focus on the points of Chloé's that I agree with, and then also share a little bit of what my contribution will be. And I'm also working within a legal framework. My aim is not to advocate for more punishment, but rather, as I think many of us here, to think carefully about how we can conceptualize legally significant deception in a way that protects sexual autonomy or reformed sexual autonomy or authenticity, as we would like to call it or decide upon, while resisting discriminatory outcomes. And I hope this can be read as one possible contribution to a broader and more transformative conversation like the one we're having today. So going to these 4 points that I mentioned of Chloé's work, first, I really value how, Chloé, you have situated the law, not as a neutral or universal system, but as something culturally and socially embedded. I think most of us would agree on that, but still on bigger discussions, this is something that is not necessarily widely accepted. So I think the analysis in the book shows that legal understandings of deception in intimate relationships are deeply shaped by historical and social contexts. This orientation, I believe, helps challenge the persistent fiction of objectivity in criminal law scholarship, particularly in the realm of sex and consent. And I find it a much needed starting point for rethinking these legal categories. Secondly, I also appreciate how directly Chloé addresses the problem of line drawing. It has also been mentioned in different contributions so far. Not all deception is or should be legally relevant. So how do we determine which forms of deception warrant legal attention or ethical attention or criminal law specifically attention? This is key, and I believe it allows us to distinguish between behavior that may be solely ethically problematic and conduct that calls for a legal response, whether through criminalization or compensation, as it has happened as well in the past or happens in some jurisdictions. I believe as well that establishing these distinctions is essential if we want coherent, just, and non-arbitrary legal frameworks, and also to have a framing, because if we are speaking from different frameworks, we might of course have different arguments and different conclusions. Thirdly, I also really appreciate how Chloé challenges what is often referred to as the ontological approach in deception. And I see this as a particularly important point. In some continental European criminal legal scholarship, in many countries of Latin America as well, in the scholarship from criminal law, for example, there's a common view that consent is invalidated when the so-called sexual act differs physically from what was agreed upon. For example, if someone removes a condom without disclosure, the argument is that the act becomes something physically different. And I think this has been discussed previously also a little bit today. Now, I think physical differences can absolutely matter, but Chloé invites us to question the assumption behind these claims. What exactly is the sex act? What is a specific kind of bodily interference, such as skin-to-skin contact? Why is this seen as the key change? Why is that particular shift prioritized over others that may also be significant to the person consenting or to certain social or socially acknowledged values? And Tolley, Rachel, when I cite you, I use your last name, but Rachel adds to this critique also by reminding us that the core concern in rape law is not merely physical harm. I'm citing now here your doctoral work, but the violation of sexual freedom or of sexual autonomy. And I would add that when we treat certain physical changes as categorically more important, we are already making a normative choice. A choice that is not neutral, and it may not reflect what individuals themselves consider most central to their autonomy. If we make that choice, at least I think it's important to present it as it is, and not only as something ontological. And that is why I find Chloé's proposal to focus on socially referenced and explicitly communicated deceptions, more or less, especially promising. I think it allows us to move beyond fixed essentialist categories towards a more context-sensitive and normatively grounded approach. And fourthly, I also appreciate Chloé's attention to the risk of discrimination. What happens when the person who has deceived is part of a structurally marginalized group, such as a trans person, someone living with HIV, or a racialized individual, and so others. And here I also draw from Tolley's rights balancing framework, or Rachel, sorry, that I believe offers a valuable complement. I really like how Rachel disaggregates sexual autonomy into 3 core sub-rights: the right to give or withhold an indication of consent, which is absolute, the right to be free from unlawful interference with decision-making, and the right to access information relevant to that decision. And it is this 3rd sub-right, the right to know, that tends to generate conflict. In many cases, the information one person might want is also something the other has a right to keep private. For example, if someone does not disclose their HIV status or gender history, and the other person consents to the sexual interaction, I do not believe this should be treated as a breach of sexual consent, nor that it should be criminalized a priori. I believe that these are deeply personal matters, and unless there is a clearly communicated relevance to the other person's decision, combined with a reasonable expectation of disclosure, the legal interest at stake here should be the right to privacy or to equality or other rights that, as have also been discussed previously, also matter for the rule of law or for constitutional order or fundamental rights. And even in cases where a person is directly asked, for example, are you a person living with HIV, or are you a trans person? And this person, when replying, provides misleading information, I would argue that we still need to tread carefully. This may constitute deception linked to consent if the other person manifests this is an important information to decide. But even then, I do not think the appropriate response is punishment for rape or for deceptive sex rape, or how we want to call it. I argue that these are complex and sensitive contexts, and in many cases, criminalization could do more harm than good. We need to weigh the rights on both sides, and that also means giving proper weight to the rights to privacy, dignity, and non-discrimination as well, particularly in the societies we live in, as has also been discussed previously in different contexts. And this brings me to Moa Bladini's important critique in one of your papers, that criminal law often lacks the capacity to account for vulnerability, particularly as experienced by women or other marginalized groups. And in this regard, I believe that Chloë and also Rachel's frameworks provide important correctives. They open space for a more inclusive and reflexive understanding of how legal standards are formed and whom they serve, even when we are working within these legal frameworks. And here I also wanted to pose or perhaps reference a question posed by Aya in the paper Aya, quoted yourself, Consent Confusion, because I have read many of you, and then I also got excited about perhaps integrating some of your positions or questions into this discussion. Aya, when you asked, the origin question is got consent, but people have wildly different conceptions about when to answer I do. I think you really nailed it into this discussion, and I think it also captures where we are today. There is growing consensus that deception or certain acts of deception in sexual contexts can be harmful, but very little agreement on which deceptions should matter in law. And that's the challenge. How can we develop principal criteria for distinguishing legally significant deception from other forms? This is where my contribution in this edition aims to contribute, drawing on Chloë's work mostly, but also on Rachel's and others, and using both inductive analysis from certain case patterns and a normative rights-based framework. I will try to propose a working definition on how perhaps we could include deceptive sex in a legal framework. It doesn't have to be, of course, about prescribing punishment, or I also don't want to suggest that every act of deception should be legally sanctioned, but I want to give a proposal for thinking about which deceptions are serious enough. Perhaps that includes both active and passive forms of deception, but that it also incorporates the idea of reasonable expectation, making space for social and cultural context, and that it also recognizes that even when a person is misled, there may be overriding fundamental rights, such as privacy, dignity, or equality, that justify not criminalizing the deception or non-disclosure in specific cases. In that sense, that's what I will try to also do for this contribution, to try to contribute to this broader evolving conversation. And of course, always trying to remain critical, attentive to power, and aware of the structural inequalities that shape both deception and its consequences. Thank you very much.
Thank you so much, Christina. And I think that's an incredible place to stop what has been another really great panel. So thank you to our second panel. We now have 20 minutes for discussion, though I should mention that we have until 2 p.m. if needed to make sure that everyone has a chance to contribute to this wonderful international exchange. I'll start by inviting Chloë to offer any immediate responses to the presentations. I also know that Beatriz wanted to respond to Rachel's earlier comment after the first panel discussion. So Beatriz, please do go ahead straight after Chloë, and then we'll open the floor to questions and cross-panel dialogue. So Chloë.
Okay, I should say I'm also happy if Beatrice would prefer to just say something now. I'm happy to just hold off for it. Or would you, I'll just stick with what you said. Sorry, Sarai. I will say a few things and stick with the order.
You do have an opportunity to respond more generally. So if you don't have any immediate responses, we can keep
on the last three papers, I will just say, like, these are extremely helpful thoughts for me and really important points. I think that what came through very clearly to me was the extremely real and significant risks around discriminatory effects, shoring up problematic assumptions, restrictions of agency through criminal laws that are supposed to be agency enhancing. I have a couple of examples of things that may help a few of the authors, but perhaps I'll just actually email them in case that's useful for them. But yeah, I just found that all incredibly helpful. So I'll wait until the end and maybe say a bit more and leave space for others to say something.
Thanks, Chloë. Beatriz, do you want to share your early response?
I would like to do that, but I want to give place for people who want to make comments to the panelists of the second round. So if there is time at the end, I'd like to comment. Otherwise, I'm glad with that.
I think please do go ahead. And then for everyone else, please raise your hands. The floor is going to be open for this. We do have a good 20 minutes. I know that there were a lot of points that we all wanted to respond to. So Beatriz, do go ahead. And everyone else, please do raise your hand.
Okay, so I want to thank Tolley for the comments. I just wanted to clear some points that, well, although I'm making a distinction between sexual freedom and autonomy, the point I'm making here is that I think that freedom express better what is at stake in criminal law than the idea or the concept of autonomy itself. But I think it makes no difference if we are working with the idea of sexual freedom, of sexual autonomy. We do have to ask which kind of interests each sex crime is actually protecting. So it's a common sense, I would say, for the most part of current scholarship, that autonomy or sexual autonomy isn't a right who should be protected as a whole by sex crimes, by criminal law. Actually, some aspects of this right actually matter. I would put this like that. And my question here was first to understand what is actually covered by a crime as rape or sexual assault. And in this sense, I really think that it makes sense to distinguish stealthing than the lie about the pill. I don't want to make the argument for this again, but at the end of the day, I think stealthing is a case for rape, but lies about reproduction or diseases does not. But it doesn't mean that it isn't important at all, and that it could not be object of other kinds of crimes. Just I don't think the problem is that we are offending a person's sexual autonomy or right to sexual freedom. It's a problem for reproduction, for example, or for health issues. So if this is going to be a crime, I would say in other realms of criminal law. But in one sense, I understand Rachel's concern and as well as Chloe's concern in the sense that in the case of lying about fertility or health diseases, the person is at the end of the day having sex as she wants, imposing sex as she wants against the deceived person, or having inducing intimacy for her own pleasure's sake. So I understand in the sense that sex is the means for, or deception is a means for that, but not, I wouldn't say that in this sense, autonomy or sexual freedom are really being the injured interest here. So thank you.
Thanks, Beatriz. I'm sure that there will be further responses to that. Tatiana, I see that you have your hand up. Please unmute yourself.
Thank you, Sarai. Congratulations to all the panelists. It was super interesting, as all the speakers in this morning, in this afternoon, actually. And I would like to make a small comment and a question to Preeti, because I found it very interesting, the view about the situation in India, and especially those situations of deception regarding religion status are some one type of cases that really caught my attention. I know that there is a case from the Israeli courts, I guess, where a Muslim man was convicted for rape by deception due to having misled their partner to think he was Jew when he was actually Muslim. And my question to you, Preeti, I would like to know if I understand and I agree to you that there is many of those laws, as they have been passed in India, they have this persecutorial proposal. But do you see any valid reason to prohibit this kind of deceptions regarding religious status, considering especially in India, if religion has a special status for people in the people in the country. So if this is generally considered to be a really important information about your partner when you're considering to have sex or any intimate relationship, I would love to hear more about your opinion in this matter. Thank you so much.
Thanks, Tatiana. Thank you for that question. So regarding the reasons why such laws are increasingly being enacted, I would say yes. I mean, religion does play a big role in the public and private lives of Indian citizens, or at least it has played for the longest time. But what has been happening for the last decade or so is that the government which has been in power is right-wing and is extremely leaning towards turning India from a secular republic to a Hindu republic. So they want to make it a theocratic state, and they believe that Hindus, people belonging to the majority Hindu community, have the first right over citizenship in India and over calling themselves Indians. So in that sense, many different laws have been passed, including amendments to citizenship laws in India, bans on cow slaughter and beef eating, because cow is considered holy to Hindus, to Hindus in many parts of the country. Again, like there's a very the project is very homogenizing in the sense that there's only one idea of what being a Hindu and being a good Hindu means, and that is being forced down people's throats even when they don't like it. And there's very little avenue for resisting, because again, like, protests have been criminalized, student leaders have been arrested, and the situation is quite bad in that sense, even though it doesn't come out in the international media very often. So why is it that this has been happening in the past decade or so, or like 5 years, more so after 2019, when Modi was elected as prime minister for the second term, and now he's in his third term of being prime minister? Is that I mean, why this has been happening is that the Hindu nationalist project is also very closely tied to the patriarchal project. So it is like, Hindu women are supposed to be the guardians of Hindu honor, of keepers of honor in that sense. So if a Hindu woman gets married to a Muslim man, and the Muslim is seen as the enemy, so if a woman from your community gets married to someone from the enemy community, then it is seen as that she has now become Muslim property and she's no longer Hindu property, because the kids take on the name of the father and they might take on the religion of the father. So in that sense, we do have a law called the Special Marriage Act, which legalizes marriages, interfaith marriages. So a Muslim man and a Hindu woman, or a Hindu man and a Muslim woman, they can get married under this law, the Special Marriage Act, without changing their faith, so without converting to the partner's faith. But this law has also been under attack by the right-wing government in India. That is one of the laws that they want to repeal, and they have been consistently building up this campaign for repeal of this law, so that essentially what it's going to do is it's going to reinforce the fact that Hindus will marry Hindus and Muslims will marry Muslims, and Christians will marry Christians, and no interfaith marriage would be legal without conversion. And that way it's going to be pretty similar to the anti-miscegenation laws in Israel, or what was in existence in the US at some point. And this is not real. I mean, of course, marriage is a very important part of this, but it's not only marriage. So they're trying to segregate schools, they're trying to segregate residential neighborhoods, and all of that is like just building on the project of social segregation and stratification. Yeah. So I hope that answers some of the questions that you had.
Thank you, Preeti, and sets us off onto a whole new range of conversations. Aya, you had your hand up.
Yeah, thank you. I just want to say, Preeti, I really the story blew my mind of the new laws of deception, and it kind of reminds me of something in the United States that's still currently going on, and it illustrates the difficulty of really claiming that criminal law, or really any law, is in service of the proposed, like whoever's proposing it, what they think it will do. And so, like, we've had these age of consent laws forever, and they're more popular than ever because of QAnon on the right and then anti-trafficking on the left. But the number one way that they come to the attention of authorities is when an underage girl gets pregnant. And most of these are, and they apply for social welfare, right? Like they apply for welfare as a pregnant teen. And then that sort of sets off a whole prosecution. So, this idea, against the will of the victim, often it's both of them. And if the girl is pregnant, she becomes the defendant. So it's just like another example of this idea of how, it's in the name of autonomy or the names of like, but it's serving totally different political goals. And all you need to do is scratch the surface. But that wasn't my question. My question was for Chloe. Because I think on the stealthing thing, I always find it so interesting because, one of the arguments is pregnancy, like unwanted pregnancy. Of course, that can't work because you still want to have stealthing laws for anal sex, right, between same-sex couples. And, then you're not, doing the vasectomy one, the pill one. So it can't be that, right? And so then they say, well, it's risk of disease, right? Like that's a different is risk of disease, which still doesn't explain the vasectomy one. On the risk of disease, I would just say, I came across this term reading some medical literature called moral epidemiology. And there's a book by Eva Payne called Empire of Purity, and it just shows how much like the notion of disease has been mixed up in the moral anti-prostitution discussion. And so I just think that's also interesting, like that, that's not a distinction. And then you default to, well, it's skin to skin sexual contact. And that's even like the more exceptionalist than the olden sort of moral and marital reasons. It's just, it is because it is. And my thought is that that is very related to second wave American dominance feminism. So I just throw that out there.
Can I respond, Sarai, or should I hold off in case there's other
One more question. Christina has her hand up, and then
It's actually on this same discussion, because I would argue that I don't think we need to go for another protected value like reproductive freedom or to like health and so on, because I believe that can also be very stigmatizing. But I think that I also wouldn't agree that then it's only the skin to skin, or on the argument that sexual autonomy should only be understood in a physical sense. And that's something I wanted to say. I think for me, at least, understanding sexual autonomy only in a physical way is very restrictive as it is. I'm not saying then that criminal law should intervene and so on, but I think at least I start from a position that sexual autonomy also includes emotional, psychological relations, information you have to make decisions and so on. And then we can have a discussion on, okay, is criminal law suitable for this and these types of deceptions or not? But I think there are arguments that are not based on other values and that are based on sexual autonomy if we understand it in a relational, broader, socially embedded kind of way, or at least that's what I would argue. I could say that perhaps certain acts also risk violating reproductive freedom, perhaps in addition, but I would also argue sexual autonomy in itself. I don't know what you think about it.
So Chloe, we don't have any other hands right now. I would suggest that you go ahead and offer your reflections on the questions that you've received, as well as just generally on today's rich discussions. And perhaps you can also point us towards the future directions for the research in this area. So a big ask. And then we still have time for conversation afterwards. Thank you.
Oh, thank you, Sarai. I'll just say something in response to Aya's questions there, or points that she raised. I think these are all, absolutely valid points. I have seen some people argue, I think this is the position in Canada with respect to not rape laws, but laws around, no, it is actually rape in Canada because of the way that they set up their code around consent, but where there's a risk of a specific outcome, only then would the potential criminalization, prosecution arise. So in instances where there's penetrative sex without a condom, where the risk of, say, pregnancy or disease just doesn't arise either because of the nature of the sexual act, so let's say anal penetration, or because the person whose disease status is the information that ought to be known in the eyes of the law is managing that risk in such a way that transmission just isn't really possible. In those circumstances, this argument goes, there would be no case for prosecution. That doesn't, of course, rule out the possibility of prosecution where there is a risk, but that risk doesn't materialize. So, someone else in a different discussion of this book made the point about, how this kind of framing of pregnancy or illness and so on is really about, like risk of these possibilities, not the actual materialization. And so could be thought of as part of a more general kind of shift towards inchoate forms of liability, which I think is probably correct. I think I would just want to emphasize, because this goes back to something raised at the start about trans people. In the book, I try to suggest that these inverted commas other considerations such as public health goals and what we know about, say, the criminalization of non-disclosure of HIV status in respect of assault laws tells us that public health goals are not well served by criminal laws. They actually reduce trust in doctors. they sometimes actually also create a sense of complacency around taking kind of individual responsibility for sexual health and so on. So I try in the book to save space and take seriously the range of other inverted commas considerations that should be factored into decision making around not just prosecution, but actually which deceptions are caught within the net of the criminal law at all. So not leaving it to prosecutorial discretion, but saying these actually should not be capable of grounding a prosecution at all. And I also make that argument with respect to trans people, but in probably fewer circumstances than others would suggest. So I wanted to highlight, if it's not come across the radar of those who are in the chat and those who especially who raised this point, a recent paper by Alex Sharp in the Modern Law Review, which it suggests that, you know, we, including work by me, others too, we don't do enough to kind of protect against the possibility of the prosecution of trans people. So if people are especially interested in that, that's worth a read. But yeah, by way of just final remarks, I just want to say again, thank you so much. It's a real treat and honor to have people read the work and engage with it so thoughtfully and think so seriously about all the different problems that arise when we try to use law to deal with these really complicated issues and the downstream effects of decisions that may have really good reasons behind them, decisions to try and reach for law, but the consequences are very, very serious and need to be taken seriously. So I think, you know, we've got so many different dimensions here within this prospective issue. We've got kind of questions around philosophical formulations, what work they can do, maybe what work they can't do. We've got the grounded empirical analysis that I like to think my book also is rooted in, but work by others in the chat goes even further than I have, of course, and looks at many other jurisdictions. That, to my mind, is just absolutely crucial to know about, because, like I said earlier in response to someone else, I just think that no matter what kind of formulations we come up with, these are applied by people in places and in spaces, and that is just so incredibly important to pay attention to. So I'm really just so looking forward to reading what people have to say, and just, yeah, and again, into anticipation of that work. Thank you again. It's lots to do when everybody is already really busy. So yeah, I'll just say thank you, and that's all I want to say.
Well, thank you, Chloe. And yeah, thank you to all of our distinguished panelists for this engaging and thought-provoking symposium. The breadth of your perspectives, spanning multiple jurisdictions, theoretical approaches, practical considerations. It demonstrates the richness and the complexity of the issues that Professor Kennedy addressed in Inducing Intimacy. And I think the conversations that we've had today around deception, consent, intimacy, and the role of the law in regulating these deeply personal yet socially significant matters will undoubtedly continue to evolve. The symposium represents an important contribution to these ongoing discussions. For those who are interested, and we do have some online participants as well, so for those who are interested in pursuing these topics further, manuscripts arising from today's presentations will be published in the Modern Criminal Law Review in early 2026. I want to thank all of you for joining us today. And again, thank you to our panelists for your excellent contributions. And of course, to Professor Gruber behind the scenes for bringing us together. And yeah, it was really just a wonderful, wonderful discussion altogether.